Next matter to come before the court is U.S. Bank National Association versus Brad Hull et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If the appellant want to reserve any time, if you let me know, I'll kind of keep you apprised of the passage of time since I'm keeping the clock this morning. We've read the briefs, we're ready to see who you are.
Good morning again, Your Honor. Counsel. Emily White of the Dan Law Firm, here on behalf of appellant Lisa Hull-Pavlovich. I would like to reserve 5 minutes, Your Honors. In this also foreclosure case, the trial court erred in denying my client's 60B4 motion for relief from judgment without first holding a hearing. In this case, my client moved to vacate the judgment on the grounds that prospective application of the foreclosure judgment would no longer be equitable. And she supported her motion by a brief and by an affidavit laying out evidence that would establish all three of the GTE factors that are necessary to seek relief under Rule 60B.
Can you, I'm just going to start right off. How do you get past Kuchta there?
Sure. So on 60B4, which is the grounds that my client moved under, this concerns only matters that have arisen post-judgment. Foreclosure is an equitable proceeding, and the court sitting in equity has the power to do equity, both at the time of judgment and really at any time in the proceeding. And on 60B4 of all the 60B factors, this is a provision that allows a court to vacate or set aside a judgment where prospective application of that judgment would basically no longer be fair. Kuchta refers to using 60B1 for the most part, excusable neglect. And it says that 60B motions shall not be a substitute for an appeal. So in other words, you can't raise arguments that on a 60B motion that you would otherwise raise on a direct appeal.
Still has to be timely though, doesn't it?
Well, it has to be timely depending on which factor you move under. So under 60B1, yes, there's a limitation that it has to be within a year. 60B4, it has to be timely within the context of why you're raising it. In this case, my client is arguing that it would no longer be equitable to prospectively apply a foreclosure judgment that was obtained because it would be unfair to do so. And in this case, my client had really a number of financially traumatic events in her life, including a job loss, including a divorce, including a remarriage. And a lot of these events happened subsequent to the slow-moving foreclosure process. And the 60B4 motion is essentially her saying, right now, at this time, yes, we are post-judgment, but please, court, in equity, it is no longer fair that this process, that this judgment have prospective application, given that we are 2 years post-judgment, and that her financial situation has turned around. That was the heart of the 60B4 motion.
Well, didn't the 60, you can correct me if I'm
Sure.
wrong, because as you well know, we had two different foreclosures here
Yes.
today, but didn't the 60B also claim that the bank didn't have standing?
It did, Your Honor.
So it went beyond the B4.
Well, there's tension there because under GTE, regardless of which of the 60B motion, which ones you move under, you still have to show all three of the GTE factors, one of which being that you have a meritorious defense. And in this case, the meritorious defense that my client raised was essentially U.S. Bank was suing on a loan and a number of loan modifications that were between different parties. They were all with Wells Fargo or its various subsidiaries, and yet U.S. Bank is one seeking them. So that was the meritorious defense that she asserted.
Which was standing.
Oh, yes, one could say that. One could also say, relying on Holden, which came post-Kuchta, and curiously omitted any mention or analysis of Kuchta, that at the point where you're determining judgment, you have to show not only standing, but entitlement to foreclose. So in order to make a proper 60B motion, including under 60B4, yes, we still have to show all the GTE factors, and in this case, we did. We submitted a brief that operative facts that are true, would show an entitlement to relief.
Which would entitle you to a hearing.
Yes.
The operative facts includes the affidavit, correct?
Yes.
Which basically says, hey, I'm making money now.
That's right.
How would any foreclosure ever be final if that was permissible? I realize you're only
Yes.
talking about
Yeah.
this case and your client, but to follow that logic
Sure, I'm going to go a
out.
little bit further back. I was a legal aid attorney for many years, and I practiced foreclosure defense in this very courtroom for many years. And I will say that it isn't very many clients that have their financial circumstances turn around in enough time that there would be time to do anything. I think that window of cases is actually going to be quite small, of those post-judgment pre-sale that have their finances turn around in a way that would make it feasible to try to save the home. And we believe this is one of those cases, and indeed, even outside of this court, my client is actively working on the loan modification process.
Well, wouldn't that be one of the reasons you have a hearing,
Yes.
to help in that determination?
Yes, and there is case law which we've cited saying that it's an abuse of discretion for the court not to hold a hearing once you submit an affidavit or evidence showing those operative facts. It's a low bar to get to the hearing, and there's a lot of case law, Rose Chevrolet and the others, saying that, once you put that forward, you have the hearing and then the court decides. And in this case, like I said, this is a 60-4. This is really a matter of equity and fairness. That's the heart of the argument. I think that concludes my piece, unless you have any other questions. Thank you.
May it please the court, my name is Terry Posey. I'm here today on behalf of U.S. Bank. I think the court is fairly familiar with the reasons this case is troubling or challenging. We think this is a straight-up 60B analysis, and as the court has acknowledged, in the mortgage foreclosure context, the Supreme Court has addressed these issues in Cooped Up, Horn, and Holden. And the one thing that stands clear here is that the trial court denied the 60B motion for two reasons. First, it found that anything that could have been raised on appeal was required to be raised on appeal. And that's not only Cooped Up, it's also Doe versus Trumbull. This concept has existed outside the foreclosure concept. And in a 60B motion, as counsel has alluded to, one of the GTE elements is a meritorious defense. Ms. Hall identified two meritorious defenses, essentially one relating to the ability to the personal knowledge of the affiant, whether the affidavit was technically correct to receive summary judgment, and the second relating to the standing to enforce the loan modification agreements. And the trial court, as a matter of law, concluded that these could have been raised in opposition to summary judgment, were not, and then therefore are barred on the basis of res judicata. For this reason alone, the absence of a meritorious defense, not barred by res judicata as a matter of law, the trial court properly denied the 60B motion. It's also worth noting from a factual perspective here, we began the factual story of this case with the filing of the 60B motion. It's important to note that Ms. Hall filed her own answer after the complaint was filed. She then filed a joint answer with her now ex-husband. She was aware of the action. Counsel participated on her behalf, although nobody opposed summary judgment and nobody filed an appeal. These are deliberate decisions that are not excused and not explained other than with reference to she thought somebody was filing the items on her behalf. And it's also not explained when she became aware she might need to file a 60B motion. The sales in this case, the judgment in this case was in 2013. The property was attempted to take a sale several times. That was always canceled as a result of the Halls declaring bankruptcy. And it wasn't until December 2015, when another sale was scheduled for December 30th, that this motion, the 60B motion, was filed. The ruling on it was delayed again due to another bankruptcy, and after the bankruptcy stay expired, the trial court, U.S. Bank opposed it, and the trial court denied it. So as I mentioned, the trial court denied it for two grounds. First, that any of the meritorious defenses she wished to raise could have been raised on appeal or in front of the trial court, and therefore it was barred by res judicata. This alone is sufficient. The court could stop there.
Would you disagree then that just raising the GTE factors entitles somebody to a hearing?
No, it's cited in our brief, and I don't have this down in front of me in this paper, but to be entitled to a hearing, you have to allege operative facts sufficient to justify that you could satisfy this. And the court can conclude that as a matter of law, I could say that the amount is wrong and attach a detailed affidavit describing all my payments that were accepted and still be not entitled to a hearing because as a matter of law, I could have raised that issue on appeal. A hearing isn't an issue that's just given for no reason, especially when the matter on its face and on the paper is capable of being denied as a matter of law. When you raise a meritorious defense, it has to be one that's capable of being pursued. And that's where the trial court says the meritorious defenses you're raising could have been raised in the opposition to summary judgment or on direct appeal. And
So in this
therefore aren't
case, that would
appropriate.
be that it's no longer equitable? That would be the defense?
Well, this is where we get into the separation between the GTE factors. The first one is that you have a meritorious defense. The purpose of a 60B motion is to vacate the judgment, and you only do that if I have something worthwhile to oppose the case with. And you have to have meritorious defense, a 60B grounds, and your motion has to be timely. So here, when she says, I want to reopen this judgment because I have things to present, the trial court says, even if we were to have done that, your presentation would be barred by res judicata because you can't vacate a judgment for something that you could have raised either directly or on appeal. You fail the meritorious defense element, and we don't have to go any further. The second element, the 60B4 element, is that the judgment is not supposed to have prospective application, should not have prospective application. And the facts submitted in this, and this is the trial court's decision, the trial court said none of the facts that were demonstrated satisfy 60B4, that this judgment should not have prospective application. And while counsel is here today saying that this is foreclosure, and foreclosure is designed to be equitable, Judge Callahan correctly identified what judgment would ever be final if I could come in years later and say, I now have the money to make this monthly payment that I couldn't make 3 years ago. Let's undo this judgment so that I can essentially use the courts to eliminate finality here, especially given that in this case, the property hasn't proceeded to sale by operation of bankruptcy law. We're stalling you from going to sale so that we can get a new job, so that we can then get the court to vacate the judgment, so that we can argue these things that we didn't do when we participated in the case in 2013. This would vitiate finality of judgment principles if prospective facts, being I now have the ability to make a monthly payment that I couldn't make 3 years before, was sufficient to justify summary judgment.
Might be sufficient to justify a mediation, though.
And the parties have engaged in loss mitigation efforts, and that's still ongoing. But one of the reasons that's still ongoing is because the property hasn't proceeded to sale by the actions of the Hulls in declaring bankruptcy. This is, it's always better to keep a homeowner in its house, and I can't tell you today that this case won't resolve with a loss mitigation effort. But when we're talking about we're talking today about whether the trial court erred, and there's no discussion of any 60B4 case that the ability to satisfy an ongoing monthly payment 2 years after judgment is ever a fact that would say that the underlying judgment shouldn't be given prospective effect.
And I don't want to take up your time talking about mediation, only to raise the awareness that we do have mediation in the Court of Appeals too.
And that's where the process, especially the further out a party gets from judgment, becomes more and more challenging to resume a monthly payment that a lender is entitled to wanting or desirous of accepting. And that goes back to, we have a judgment. We have an enforceable judgment. And the ability to execute on that is clearly carefully weighed against the receiving prospective future payments and resuming the loans in evaluating a loss mitigation effort. But that doesn't take away from the fact that we used our rights to go to court. We used our rights to obtain a judgment of foreclosure on this property. And for whatever reason, Ms. Hall did not choose to defend summary judgment and did not choose to appeal. And that leads to really the last element here. The trial court didn't address the timeliness factor, but this was...
So can we?
We believe this is alternative grounds for affirmance, or at least, and specifically, the standard review here is abuse of discretion. Let's begin with that. And so to the extent that the trial court found as a matter of fact that these were not 60B4 grounds, that's not subject to a de novo review, it's subject to a abuse of discretion review. I would agree and would consult that a decision saying that there are no meritorious defenses as a matter of law is subject to a de novo review. But the trial court bootstrapped its decision. But just for the purposes of consideration, trial courts have regularly found that decisions that are not explained why it's taken so long for someone to show up seeking 60B relief beyond a year or for a ground not decided in 60B 1 through 3 are appropriate for denial. This argument was raised below. The trial court didn't address it. We didn't file it as a conditional cross appeal, but it's another thing here that indicates this motion was correctly decided. It didn't satisfy any of the GTE grounds. There were no meritorious defenses that were not barred by res judicata. 60B4 shouldn't apply in this type of scenario where the borrower says, I'm now capable of making a monthly payment that would satisfy you. Well, this is 2 years after I've obtained a judgment. Accelerated the loan, calling it all due, and received a judgment to that degree. And lastly, the motion was untimely. There was no explanation as to the timing of which it was filed, other than her counsel did not oppose summary judgment, which she wished them to do. She didn't indicate when she learned there was a judgment. She didn't indicate what she did in response to that. All factors that courts have considered in appropriately deciding that a 60B motion is timely is some context in which the motion was filed instead of in relation to running out of bankruptcy stays and the property proceeding to sale in the near future. For these reasons, we would discuss and respectfully request that the decision of the trial court be affirmed. Thank you.
Thank you, Your Honors. I'd like to respond to two small points. First is finality comes with the confirmation of the sale, and we acknowledge that. I believe the universe of cases in which this scenario would come up is small, but they're also going to be the most heartbreaking for a client. They certainly are the most heartbreaking for me as an advocate whenever a client comes to me post-judgment with a new job or new income or a significant change in their financial situation that makes it possible that they can save their home. And I do believe that 60B4 was made for just this situation. I would also invite the court to take a look at the actual affidavit that my client did submit. That does explain a little bit more of the factual background. It's 3 pages. I believe it's part of the record.
I know you're pushing on time here, but I have a question about
Sure.
that. Does the law require the operative facts to be in the motion itself? I guess another way of saying that is your operative facts that you're relying on were only contained in the affidavit, correct?
That's correct.
Is
Yes.
there case law that requires that it be in the motion itself?
Well,
I'm inferring that that's what the trial court or magistrate relied on. but-
Your Honor, there's, I believe, like a 12-page motion that goes into the detail. You are right. Some of these factors, the GT factors, are based on legal arguments. So they're outside of the scope of my client's ability and personal knowledge to testify in an affidavit. But many of the facts that I believe are most pertinent to equity are contained in that affidavit and explain a little bit more of the story. The other thing with respect to timeliness that I just wanted to respond to quickly is for 60B4, for multiple reasons, the relevant time is not what happened before judgment, it's what happened after judgment. It's what happened after the thing that made it no longer fair to proceed. And so the question for timeliness is, after the equities changed, did my client wait too long in presenting this motion? And I believe not. There is both case law and the text of 60B itself. If you look at the last sentence of 60B, whenever it speaks to timeliness, it says with respect to factors 1, 2, and 3, it has to be within a year. 4 and 5 are omitted. There's a reason for that, because number 4, equity, would only come up for situations in which it would be no longer equitable prospectively. So I believe that this motion is timely raised. I also believe that the affidavit and the record established operative facts that would have entitled my client to at least a hearing. And I believe also that a meritorious defense has been asserted, although I will say that the GTE factors are kind of an unhappy fit with the actual text and elements of 60B in this case. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all sides, as well as posted on the House Supreme Court website, which you can get to by linking through our website if you choose. We are adjourned until next Tuesday, so thank you both.